Good morning friends, Sat Sri Akal, Adab, Namaskar. This is my 197th video and this is a video which will be a mixture of two issues. One, we will discuss the making of Jabalpur Cantonment, and then there was a case filed by some Mr. Puran in Jubbulpore in 1924. So what happened and what is the status of the case? And this book, I'll be grateful, he's no more, Mr. Indu Rakhya ji had shared it with me when some agriculturists who were owning some piece of land, approximately about 445 acres, had shared these books with me with some of the then villagers, and they wanted to pick up some advice, but which never happened. So this book is basically a small compilation on the agricultural lands of the Jabalpur Cantonment boundary pillars, written in 1924 by Mr. A. Kidwah, who was then the executive officer. Now it varies that Jabalpur Cantonment was created in 1826. Now from 1826, when Jabalpur was created, on one pleading it says it was after season. Season means that you won through war. So the area or the entire terrain came under the British rule. The Charter Act of 1773 says that there will be no war to increase the dominion of the British government by the Queen of England. So these are two contradictory statements in this entire findings. Indu Rakhya ji used to talk to me, but somewhere while on his talking, he used to be talking more about his individual bungalow. Unfortunately, his sons don't even want to be a part of this association or this group, and generally both of them, they would delete themselves from the group. Leaving apart, today I am talking of Jabalpur. So there is a correspondence by when this officer was making this report, when 445 acres of land, which was the original in 1826, was taken over, and a military cantonment or a station was created. But he goes on to state that there is no record of 445 acres, how it was taken, what were the boundaries. So this letter of 1856 does not speak of anything like that. So what does it speak? Major W.C. Erskine, then the commissioner of Sagour of the Northwest province. So are we trying to say by this letter that Jubbulpore fell under the Northwest province? It was not a part of the Bengal presidency or the Madras presidency or Bombay. So this is very important. He goes on to say that I do not find any record in my office nor from inquiries made from elsewhere when the present boundaries were fixed. But the plan in this office of dated 20th October 1826, signed by the Deputy Assistant Quartermaster General, Bengal Army, Mr. C Fraser, who was then a political agent to Major Day commanding at Jabalpur. So there is a plan. Now what does this plan speaks? We can always bring it in evidence. In 1837, some bungalows were encroached upon, and whether permission was confirmed to increase the limits of these bungalows is not coming on records, and neither it is there. Boundary pillars could not be confirmed, so there was a letter written to the Commander-in-Chief of the Madras Presidency. On one way in Jabalpur, there is a Northwest Frontier Commissioner who is writing a letter, and the same commanding officer of Jabalpur is writing to the Commander-in-Chief Madras, because Jabalpur is in the Madhya Bharat, it's the central core. So it is not been decided whether Jabalpur is in which part, Bengal, Madras, Bombay or Northwest Frontier. So friends, this becomes very important. People at that time didn't know about all this, that these three presidencies had their own areas. Please go and look into my 1833 boundary pillars map and then the 1887 boundary pillars map. You will see where Jabalpur falls. So now there is a notification of 408 1861, which says that okay, we have a boundary of cantonment. Now what is that boundary? 1861 notification, that is also not coming on records, he says. There is nothing, there is only a reference to it which is coming. Now what are the villages which have been taken? So the villages named are Katanga, 99 acres of land has been taken. Barochi, 693 acres of land. Pachperi, 8 acres of land. Jamnera, 61 acres. And Balheri, 206 acres. The other village was Gorapat, 439 acres, which total amounts to 1508 acres of land. In 1861 was notified from 445, which was originally in 1826. So in 1869, an added area of 524 acres plus a 63 acres of land which is declared to be private, it says. Now, in this case, he comes up with a theory that this 63 acres of private land which was taken over, there is a notification number 71 of 1870 under the central province of Govt. So that means Jabalpur fell in the central province now, where 62 acres of land was from the village called Gutanka and 1 acre was from the Mauza of Gorakhpur, and an amount of 1970 rupees was paid as compensation for only proprietary rights, not for claiming possession. So now we have to understand that the 1870 Land Acquisition Act spoke of kind of acquisition. Are we acquiring possessory rights? Are we acquiring proprietary rights? So this was the question. So here he says we acquired the proprietary rights but not the possession. Possession rights who will give? That has to be understood. So meaning by the Land Acquisition Act, whether it was 1854, 1860 or 1870, which of the regulations actually brought in under these laws and applied on this 442 acres of land, either in 1826 or in 1870, added 524. So when the implementations of CLA rules in 1925 was being taken over. Now CLA rules in 1925 very clearly said that there is going to be a revenue record called the Journal Land Register. So Lieutenant Colonel Lawrence, who's explicitly explaining all this, how under Rule 13, Sub-Rule 13, leases are made and how these leases were given to those people who had been sitting from 1830, which he admits. Now, I am sitting in this property since 1830 by an admission of the government, but in 1925, the government wants to make a lease of my property. Just imagine, from 100 years or 95 years, they didn't make a lease, but now they want to make a lease under the 1925 Sub-Rule 13. People didn't object to it because we were slaves. So here the DC is mentioning that even after taking leases of such area, there were some areas in Jabalpur now which are named as Pirji. This is a piece of land near Sadar Bazaar, and Purana Darju. This is another piece of land near the Indian Troop Hospital then, 1924. Now what is that property that right now known to the Jabalpur? In these two properties, the proprietary rights were never acquired. So that means land within the cantonment boundary pillars are private and could be private. So friends, we have to understand, now from the old records of land, we were shifting to the new records of land made under CLA rules. Now, whether a record of rights were ever made for Jabalpur, he doubts. He says there is no such order or notification coming. So the points what the DC takes is that unless and until the claim of agriculture tenants are established, So now these people who are sitting from 1830, are they tenants? Are they lessees? Before taking any drastic step enforcing these new rules, it will be fair to clarify whether these registers have to be done or not. So whether it is advisable to make these new rules is a matter and subject of law. So these villages which were never leased out in 1830 in a very ordinary manner to these thekedars, according to the settlement reports, where 30 years of possession gave proprietary rights. But here it comes up with a report that the land record is showing that in the column of ownership, the Malkiyat is of the Sarkar. So these owners who've been sitting in this property could not have claimed proprietary rights, because neither the government was the owner of this property. So who was actually the owner of the property? Government, I mean here, is the Ministry of Defence now, or the then British Army. So who's the owner? Now the DC says there is nowhere where I can see a settlement report of these areas or this agriculture leases where the boundary pillars were created. So whether these occupiers were to be termed malguzars as old cultivators who had to be conferred proprietary rights. In the incident here, he says they were termed tenants. Now if you are terming somebody as tenant, the law was very clear. That means it was the government who was a Rotwari, which could not have been. A government can never be a Rotwari of his own land. Government either has to be the owner, because we consider the government to be a complete sovereign. So it is an undecidable story happening, that whether these tillers or occupiers were tenants, Rotwas or Malguzars is a matter of concern, and these settlements never took place. So in 1861, these lands, when finally were handed over to the cantonment, and when these boundary pillars he admits to be have been made, not in 1826. So these owners, these occupiers should have been given occupancy holdership rights. That was also not provided. So this must have been that the cantonment committee must have claimed itself from the government as Musfadaris. Now it's very interesting what this report says. The DC is saying that it is the cantonment authority which must have been the Musfadaris. So they were not the original owners, because they had never acquired these lands. Further on, they could not have given tenancy rights as they themselves were Musfadaris. So the actual cultivators now is protected by this Musfadari, which is the cantonment authority or committee, for an arbitrarily ejectment from the property. So this right I tender to the occupiers of this agricultural land. So the khasras we find in the proprietary column, the Malkiyat Malka Moza, which means Malkiyat is of the Sarkar, and no mention of cantonment committee or authority is written there. So who is the owner of Jabalpur agriculture lands? It is the DC and the government then. It never transferred to the military or the British Army. So this must have been done to show that cantonment committee was as Musfadaris, and who further gave tenancy rights to these cultivators to protect themselves from ejectments. And the DC was very clear in not mincing any of his statements, and states that in old Rapgar of land records talks of acquiring these lands for cantonments. Nowhere. What will acquisition mean other than conferring or assigning proprietary rights, or possibly the mere inclusion of the area within the limit? So the DC is without any mixing is clearly stating that there could be no proprietary rights of the cantonment authority without compensation, ousting these tenants or giving them occupancy rights if they were so, and then further compensating them. So these plot owners were directly tenants to the Government of India and not to the cantonment authority. So their rent has to be fixed by Government of India. In the central province, Rule 20, the rule is very clear that 20 years of occupation or rent has to be fixed for a tiller or an occupier. So the DC is so clear that these lands were never acquired. So since 1861, and this report is being made in 1924. So he mentions some plots 49, 62, 87, 88, which were declared under classification A lands. That means they were in active occupation of the army. Similarly, the revenue rates were increased of these plots. Now, revenue rates mean that this is the Lagan. So, somewhere 283 rupees 53 paisa or something like this was done. So, there is a complete list of owners and tenants which is mixed here. Now, this shows that Jabalpur cantonment was never the agriculture land which we are talking, which is approximately about 1500 acres, was actually owned by the government. So it is a state subject. It is not the central subject. But because of a notification of the cantonment boundary pillars, we were shifted into the Article 246 as a central subject. So friends, we have to understand why is the department or why is the constitution or why is the 1935 Government of India Act subjecting us being a cantonment property within the cantonments to be a part of a central pool. Has the central government acquired us or has the British Army acquired it? Here he is clearly saying we have not. So Jabalpur people can get in touch with me. There are two cases of Indu Rakhyaji and Mr. Sangal there, which were fought well, but with today's evidence and today's recording of the Supreme Court's in latest cases of 2015-19, I can bet those people will also lose. Indu Rakhyaji was only asking for possessory rights. He did not ask for ownership. And Mr. Sangal's father had only asked for ultra vires of the resumption notice issued to a perpetual lease. There is a judgment which has come which clearly says even if a lease in perpetuity with the terms and condition is not of perpetuity. So friends, please wake up, Jabalpur people, and let's not be so arrogant. We are old grants, were supposed to be converted into new grants, which we were not. Thank you. Good day.